And we're getting started. Hi, everyone. Welcome so much to our July monthly webinar. Um, my name is Patricia Elizee from the Elizee Law Firm. We're an immigration firm located in Miami, but we service and help clients from all over with their immigration issues that are tied to immigration or immigrating to the US. And I have with me the head of our acquisition team, who's Catalina, who's going to be helping us with the presentation today. And hopefully you guys have the chance to interact with her, because when you call the firm, she's going to be the one that sets up the meeting, individual meeting for us to review and analyze your file. Okay. Awesome.
Awesome. Thank you so much for the introduction, attorney. So if I may, I just wanted to give everyone a heads up as to who we are specifically. So as the attorney said, we are an immigration law firm. We are based out of Miami, Florida. However, we do service people all over the world. So whatever country or city you're currently in, don't be afraid to send us an email, give us a call. We'll be more than happy to attend to your questions that are immigration related in the US, right? We are available online. You can visit us at elizeelawfirm.com. I'm going to go ahead and put that in the chat for everyone to see very soon. Our phone number is 305-371-8846. Remember that if you join this presentation today, we'll definitely keep you in mind to give you a free intake the next time you contact us via our website, our phone number, or our email address, which is intro@elizeelawfirm.com. Don't be afraid to contact us in English, Spanish, Creole, or French. All right, so while we get started, I'm going to go ahead and set up our presentation, and we'll give you guys a quick introduction as to our attorney and who she is here at the firm, what she does and what she can definitely do for you next time you call.
So while you're getting that set up, just a quick reminder, we're doing these webinars every month. So every single month we try to host a virtual webinar where we invite our friends, our family, our clients who are also our family to log in to learn different aspects of what's going on with immigration. As you guys know, with USCIS and the immigration courts and policies, there's always something new coming, something changing, etc. So we really wanted to make ourselves available, and we create the time to go into one aspect of immigration in depth to really educate the community and educate folks. We are very happy to customize our presentation. So for example, one of the reasons why we chose this topic for this month, which is how to get a second bite at the apple with USCIS or with immigration, is because we've noticed when it comes to our clients, especially potential clients, they really didn't know how to go about asking again, or how to deal with a rejection, or how to really change their mindset for them to understand just because the case was denied the first time doesn't mean it's going to be denied the second time. And that's a question that we got directly from our client. So if there's any specific question you have or topic that you'd want us to go into in depth, please make sure to contact us. You can leave a comment on the chat. You can leave a comment in the video once this video is posted online, so that we can go ahead and do these presentations for you. We've done them on anything as basic as TPS or citizenship, or also as focused as this, a more technical presentation about how to go about dealing with a denial or a second request or a second chance, right? How often do we get a second chance? Getting a second chance with immigration.
Great. Thank you so much for that introduction, attorney. So without further ado, our presentation today titled How to Get a Second Bite of the Apple with USCIS. We already talked about who we are as a law firm. I'd like to introduce you formally to attorney Patricia Elizee. She will be guiding this presentation, and she will also be the attorney who will be taking care of you during our consultation times. She's been published everywhere. She's been seen everywhere. I'm sure you guys have seen her and met her in the past. Of course, she's been able to practice law in the whole country because immigration is not limited only to the state of Florida. So without further ado, shall we get started?
Yeah, let's go about doing that. So general background information. Why do we pick this topic? Firstly, the immigration system can be very overwhelming, right? Some people decide to file on their own, or if they have the capability to do so. Some people, even if they do, they prefer to use an attorney just to make sure that everything is done correctly. With USCIS and immigration overall, if you're not familiar with it, it's very easy to make an error. You're not sure what form to file, when to file it. You're not sure the difference between a status in the visa. You're not sure if you need to do the I-664, the I-64A, or which is better, adjustment of status or consular processing. So this is why we're here. Me personally, I was born in Port-au-Prince, Haiti. A lot of you guys know that. Me and my family went through the immigration system. I remember, right, um, in, I believe it was college, I was going to USCIS for my appointment to become a citizen, and it was very overwhelming. And I just remember, how anxious I was knowing that this one immigration officer had all of this power in his hands, looking at all of these documents that I didn't necessarily understand. So I get that feeling. I've been there, and I understand, and I really enjoy kind of helping someone navigate that system, right? Like going from a chaotic situation to making sure that they're protected and they're okay and that they understand. So the immigration system can be very overwhelming. Sometimes you can make a simple error, which triggers a denial or triggers an RFE or triggers annoyed, and we'll go into all of that later on. But this is something that I'm always, harping on, is the small little mistakes. It's, the wrong box that was checked, or it's the wrong documents that was provided, or a misunderstanding that causes someone to have issues on their file. I remember very clearly, for example, I had a client who was really, really upset because her whole case was denied because she filed her financial affidavit, but she didn't fill it out correctly. And immigration gave her the opportunity to fix it. And she still, unfortunately, did not end up hiring an attorney to do it. She came to us after it was already denied, after the RFE. And I told her, this is really sad, but if you had just filled out this one page, you'd have had your green card. And she was just so upset and so overwhelmed. Um, a second reason, like a second background point is, sometimes getting your green card is not straightforward as, let me just fill out these documents, right? Let me fill out these applications. I can't even say every single year, every few months now, USCIS updates their filings. They're updating the fees, they're updating the forms, they're updating this, they're updating the addresses if you send it to the wrong address. And also, very, very important. This is probably one of the most important points to make today. Immigration policies or procedures are always changing. The law has not changed, guys. Immigration law has not changed. So let's take a step back. Immigration law is created by Congress. Immigration law can be changed by Congress. That has not happened in years. Obama wasn't able to get it done, right? Trump was not able to get it done. Biden wasn't through Congress. All of the changes that each administration did was not in the law, but in the policies and procedures. And they have the right to do that because remember, the executive branch, which is obviously under the president, is the one that executes the law and is in charge of all of the federal agencies, including immigration. So the way that they process these immigration cases through their discretion is through their internal policies and procedures that are always changing according to the way that they want to execute the law on the books. So, which is why we're always getting these new programs, and there's these lawsuits that come up saying, oh, that's outside of your power. So, TPS, policy and procedure. It's up to the administration to know whether they're going to do a new TPS or not. It's not automatic. It's up to the policies and procedures, even though TPS is part of the law. Parole in place. This is a new program that is going to be starting August 19th. This new program is going to help spouses that are here physically in the US without an I-94 or without evidence of legal entry. If you're a US citizen and you're physically here and you did not enter the country legally, through the change of policy and procedure that's going to start on August 19th, you can now apply for parole in place, making it so that they give you lawful entry, right? So that you can go ahead and apply for a green card here. The law has not changed. It's a new policy and procedure that's being put in place that's going to completely change the process of getting your green card. So these changes, for example, also prosecutorial discretion. This is a huge change that took place between the Trump administration and the Biden administration. Under Trump, it was extremely hard for us as attorneys to request the immigration officers or the attorneys to take a look at an immigrant's case and to, for example, dismiss it or to agree to reopen it or to agree to a motion to dismiss, right? Because of the policy change between Trump and Biden, now it's a lot easier for us to request a case that was already denied or a file that already has a deportation case or deportation order to be looked at a second time through this change of policy. So just because you had a result in your file 10 years ago, 15 years ago, or even 6 months ago, doesn't mean that is going to be the same now, depending on what's happening, depending on all of the changes happening, which is why it's really important to sit down with an attorney that can review your case and to see, listen, I see what was done before. This is what the law is, or this is what the policies and procedures are now. Yes, we can try to do something, or no, we cannot. It kind of just depends, right? It depends on the change that's happening and how it's going to affect your particular situation. But you definitely need to be open to the fact that a change may have a really great impact on you refiling or the timing of it. So just keep that in mind.
Attorney, it's super interesting that you're pointing this out before the presentation, because that brings us to conclude that this year is a really important year for the availability of these resources and the future of the same.
Yes. So with the upcoming election, guys, right? This is definitely something that we've been very mindful of. There's some programs in place now. There's a new program coming in, or the ability for us to take advantage of Biden's prosecutorial discretion, policies and procedures to request the cases to be reopened and dismissed, or for the cases to be dismissed generally, even if they're in deportation proceedings. That may not be available if a Republican takes over the White House. So
Agreed.
the upcoming elections are extremely important because, as everyone knows, immigration is one of the #1 topics in the election right now. And there's going to be a lot of changes for immigration in the next administration that takes over.
Perfect, attorney. So let's move on to the object of today's presentation. So I've received an RFE or an NOID. What now?
Great. So the RFE and the NOID or NOID are really USCIS giving you a second chance of getting the evidence and the information to them the way that they want it so that they can make a final decision. So typically, when you file a case, what happens is you're issued receipts, USCIS receipts. They will process your file, they'll put it in line. When they finally get to your case, if everything is in order for them to make a decision, then they will continue with that case. So for example, a lot of people, this is again another change in policy that happened. 2 or 3 years ago, we were not filing the adjustment of status cases or the green card cases necessarily each time with the medical record, because by the time immigration got to the case, the medical exam had expired. This is something that Biden changed. So before, if the medical exam was not part of the case, they would issue a request for evidence for you to then send in the medical for them to make a final decision. Medicals right now, change in policy, do no longer expire. So for
Mm.
us at our firm, what we try to do is to submit an application that is complete as possible from the very beginning to limit the risk of delays with a request for evidence or annoyed, right? Um, if the immigration officer gets to your file and they see that either the financial documents of your US citizen sponsor are incomplete or not correct, they will issue a request for evidence or annoyed to get that information from you. It is your duty to provide that information back to them timely before the deadline so that they can make a decision. If you miss your deadline, then immigration can definitely deny your case, right? Because you haven't given them what they needed in the time frame that they gave you. So the big difference between an RFE and a NOID, the NOID tends to be a little bit more aggressive. They're very similar in the fact that it's a letter that you're going to receive either through your portal or in the mail that tells you this is what they think is wrong with your case, and this is what you have to provide to them by a specific time so that they can make a final decision. And it could vary as when it comes to maybe the the medical record, the financials, very often also it's the birth certificate or the marriage certificate that's tied to the case. Each country sometimes has their own specific rules and regulations to what documents they're supposed to provide. So, for example, in some countries, you need to provide the birth certificates. In other countries, you have to provide the archives, or there's the long form or short form of a birth certificate. For in Canada, there's a short form, there's a long form. In Haiti, there's the birth certificate, but then there's the extract of the birth certificate. If you provided the wrong format to immigration and they see that, then they can definitely issue an RFE asking for the proper documentation to be provided, giving you a second chance to provide the correct information to them. If they see that you've been arrested, for example, and you didn't provide the documentations necessary for them to review your file, they will for sure issue an RFE asking for the full criminal records from the arrest decree, from the court records, from the disposition if it's missing in the file. So
Attorney, one of the questions I have in the question log right now is which cases are susceptible to receiving RFEs and NOIDs?
that's a really great question. So to be honest, is any case that is pending with USCIS. Any case that is pending with USCIS. So it can be an I-130 for family-based petition, right? It can be a TPS application. It can be a work-related petition. So for example, for TPS, I've had RFEs issued for clients because immigration wants them to file a waiver or a pardon. So if immigration sees there's something in your file that's blocking you from qualifying, they will give you the request for evidence for the TPS to say, listen, you need to file this waiver for the TPS for you to qualify. Or I've done cases, for example, for work visas, especially for artists and musicians, especially P3s, P1s, immigration can see that, okay, we need clarification on your itinerary. So please provide us the documentation that we're seeking, or we want to make sure that this artist is culturally unique to their country. We need this additional information. So really any case with USCIS.
Alrighty, thank you so much for that, attorney. So how do you suggest we go on about getting the RFE or the NOID sorted?
So you have to be mindful again that this is USCIS telling you, listen, this is a yellow flag. We just, we just finished Copa America. Everyone has soccer on their mind, right? An RFE or a NOID is kind of like a yellow flag. And it's your one chance to address it with them. to make sure that they receive everything in order to get it approved. The most important thing is to take your time and to read the request, the RFE or the NOID, very carefully, very, very carefully, to make sure you understand what they're asking of you. Once you do that, you want to make sure to prepare a reply and get it to immigration before the deadline. Very often, if someone was not using an attorney before, they'll probably reach out to us and say, listen, we got this in the mail. We don't know what they're talking about. Please help us, which is when we would sit down and try to take a look at what immigration is asking, the evidence that they provided, and really try to make sure we supplement and we answer in an effective way so that immigration can approve it. You want to make sure you have the evidence, that it's clear, it needs to be translated. Any documentation that you're providing to immigration that is not in English has to be translated. So a lot of people make that mistake as well. So be prepared, read the evidence, make sure you don't miss the deadline, and make sure that you send back everything that they're asking for. So it's very typical of USCIS. They can ask for 3 different things, but it's all in paragraph format. So you want to make sure you go in and kind of circle everything they're asking for, because if you answer with only 2 or partial reply, you're also at risk of having the case being denied.
Awesome. So what if I don't have the evidence, attorney?
That is a very great question. Number one, there are typically 2 reasons why someone may not have the evidence that immigration is requesting. Maybe that you don't have access to the documentation, or maybe the authorities that you need them from are not available, or the documents don't even exist, right? So, for example, if someone is asking you for evidence that you are evidence that you have that the child that you're petitioning for is your actual child, right? Let's say you don't have the birth certificate. Well, you want to make sure that you provide as much documentation that's comparable. If you don't have access to that birth certificate, you want to make sure you reply explaining under oath, this is what you're asking me for. I don't have it. This is why I don't have it. However, here are comparables. So maybe you have the baptism certificate. Maybe you have photos. Maybe you have sworn affidavits from family and friends. At times, the evidence may not exist at all. So we had a situation where we had a client who had a DUI in France, in Paris, and immigration was requesting the records. The records don't exist per French law, right? The records just are not available. So we had to reply with the evidence that the records were not available. We had a sworn statement from an attorney in France. We had the law in France explaining why the records were not available. And we had the court records also, something from the court stating, listen, these records were destroyed a while ago and they're not available anymore. So the point is, whether you don't have access to the documents or the documents don't exist, you still have the obligation to reply, and to reply timely to USCIS. If not, then you definitely will run the risk of having your case be denied.
So attorney, just to kind of wrap up what you just enlightened us with regarding the evidence, it's essentially really important to get creative with what we give USCIS.
So if you don't have exactly what they're asking of you, then you definitely want to reply as to why you don't have it, or I don't have it, but this is the closest I can get to what you're asking for sure.
Okay. Now, what if I get annoyed?
So if you get if you get a notice of denial, right? Which means that immigration has said, we're denying your green card, we're denying your TPS, we're denying whatever you're asking for. It doesn't mean that the case is necessarily done. What it means is the immigration officer has denied your file, but there's things that you can do to get it reviewed, right? So, for example, in certain circumstances, we've done appeals. You can appeal a denial. Or, and there's certain other circumstances, you can do a motion to reopen and explain, listen, per policies and procedures, this is a mistake that you've done. This is what was provided. This is what was done. Therefore, you got this, you made the wrong decision. Or you can do a motion to reopen and to reconsider if you have additional evidence for immigration to consider. So getting a denial doesn't mean that it's the end of the road necessarily. And I can think of two situations, one dealing with an I-130 for a US citizen that was petitioning for his spouse in Jamaica that got a denial of the I-130. And the other one was a client who got a denial of an I-485 because of the financial affidavit when he was physically here. The client was in New York. So in the first place, we had a US citizen who came to us because he did a marriage-based petition for his wife. He's a little older and he's in Florida. His wife was in Jamaica and USCIS denied it, saying that he did not provide enough documentation to show that it was a bona fide and real relationship. So what we did is we actually did a motion to reopen to reconsider where we provided a lot more evidence. So we did a sworn affidavit. We looked at the evidence that he provided to immigration the first time and also to their request for evidence, right? We explained why the evidence that he provided should have been enough by itself. And then we also provided additional evidence. So that motion to reopen and reconsider was approved, which means the I-130 then went from being denied to being approved. And the case was able to move forward to have his wife come to the US and apply for and get the green card through the procedures. Doesn't mean that, that denial for them didn't mean, okay, it's done forever, or that they had to start over, because they came to us timely and were able to do the motion for them effectively. In the case of the client that was in New York, he was getting his green card from his dad. They filed a financial affidavit, again, replying to a request for evidence. It wasn't done properly at all. And we were able, after the denial, to file a motion for USCIS to take a second look at the case, etc. And that's being processed right now. So at the end of the day, a denial when it comes to your immigration case definitely does not mean that it's the end of the road. You can either keep going and fighting that exact same case, trying to get immigration to take a second look at it, or we can determine, listen, we just have to start over with a second file and just redo it from scratch. That can also be the case. It just depends on the situation.
Thank you, attorney, for that. So who do we need to keep in mind when we're doing these petitions that you're speaking of?
So every case is going to be different, right? You can have your case be in front of USCIS, which is, United States Citizenship and Immigration Services, which is the federal agency that adjudicates applications. They make decisions on applications. They're the ones who do background checks, fingerprints, etc. Or your case may be in front of an immigration judge, and that's going to be in front of a completely different agency, which is EOIR. USCIS and EOIR, sometimes they overlap, but each one has their own way of working things. So, for example, if you're applying for asylum, you apply with USCIS. If you're applying for an affirmative asylum, meaning you weren't already in deportation and then you applied for asylum. So let's say you come in with a tourist visa, you apply for asylum. You apply for asylum with USCIS. If it's denied, USCIS will send your case to immigration court, right? To be reviewed. So, or if you're doing a green card application, you're doing it with USCIS directly. if it's denied, then it can be sent to the immigration judge to start a deportation case. Or sometimes someone starts with USCIS for an asylum, that's denied, it gets into the immigration judge looks at the asylum, denies it as well, but then the person can go back to USCIS, file for a green card, and then we have to determine, okay, well, who has jurisdiction or who has power to make the final decision on this pending green card? Is it going to be USCIS? Is it going to be OIR? It really depends on the person's legal status, how they entered, and that's something that we'd review during our intake and when we have, obviously open cases to figure out who do I need to go back to get the final decision or to get the case reopened. It's very often, for example, that I will do a motion to reopen with immigration court to get the deportation case to be reopened so that USCIS can approve the green card after the deportation case is reopened. So each case is going to be different, but for the most part, we're going to be looking at both agencies to figure out, okay, where's your case now? What was done in the past? Who has the power or who has the jurisdiction to make a final decision right now moving forward?
Attorney, thank you so much for mentioning that. And because we're on the topic of each case being so different, we encourage you to reach out to us at elizeelawfirm.com. You can fill out one of the website submission forms, or you can email us at info@elizeelawfirm.com. Call us at 305-371-8846 to request your complimentary intake so we can look at your specific situation to see if any of these topics that we're discussing today are going to benefit your situation.
So this
All
slide
right.
just highlights exactly what we just went over, which is, you really want to figure out, where do you need to do the appeal? Is it USCIS? Is it immigration court? Because both cases, whether a case is in front of an immigration officer with USCIS or in front of an immigration judge or the Board of Immigration Appeals, in both cases, you have the ability or the opportunity to do an appeal. And in both cases, you have the opportunity to do a motion to reopen and reconsider. And if you go to the next slide, you'll see, for example, okay, so we're talking about the different terms. Let's explain them. So the motion to reopen is when you're asking the court or USCIS to review the file because you have new facts and the supporting documentation. Motion to reconsider is, for example, when the person who made the final decision you believe made an error per the law and you want them to take a second look at it. And sometimes you can do a combo. So the motions to reopen, to reconsider, or also appeals can be filed both with USCIS or with the courts. And if you go to the next slide, there we go. So you'll see that for USCIS, for the most part, the appeal needs to be within 30 days. And in immigration court, it kind of just depends on the situation, because we've done motion to reopen years later when the case is with in front of an immigration judge or the Board of Immigration Appeals, because of certain policies and procedures that we're able to take advantage of at the time. So right now we're doing a lot of motions to reopen and reconsider after we get prosecutorial discretion from ICE from cases that have been closed 5 years ago, 10 years ago, 15 years ago. Because the person now qualifies for the green card, we can show that they're a person of good moral character, that they merit it, we have the documentation, and we know exactly where we have to go to request that to be done. So, something to consider: the eligibility, documentation, and deadlines.
Thank you, attorney. So let's move on to an appeal.
So an appeal is going to be where you have an initial denial, but that doesn't mean, again, that's going to be the end of your road. If you're not doing a motion to reopen and to reconsider, in certain circumstances, you can appeal the case. So for USCIS, you'll send it to the next level, right? For a higher officer within the agency to take a look at it, which is typically AAO. And then when it comes to court, If the immigration judge denies it, then you can appeal it to the Board of Immigration Appeals. For the most part, you're going to have a second tier, and sometimes you can have third tier, fourth tiers, where you can appeal. You can even end up in federal court because you've appealed the case so much. So you can get someone to review the decision that was made prior on your file.
Okay. So I'm thinking that if we have cases that we're working on from 15 years ago, 20 years ago, 10 years ago, I'm going to need a copy of the full file in order for you as an attorney to be able to really see what can be done and what had to be done already. Correct?
Yes, very much so. And as it's stated here, it definitely saves a lot of time and a lot of money. Why is that? Having a copy of someone's full immigration file. So what does that mean? Even though there's been several applications, even though there's been several different attempts, even if you've been in front of a USCIS officer and then in front of the judge and then you did TPS, but then you did this, and then even if you had 20 people apply for you, at the end of the day, you have one file with immigration. They fingerprint you, everything is consolidated, you have one alien number for the most part. So having a copy of those file really helps an attorney review legally what happened in the file and what needs to be done moving forward to unlock the case. And we do that by filing FOIAs, which is Freedom of Information Act. This is a procedure that you can undertake for each different federal agency. Now, within the immigration world, is very often that we're filing FOIAs with USCIS because USCIS will have copies of all of the applications and decisions and evidence that were submitted on your behalf. CBP will have all of the documentation regarding your entries and exits in the country. So if that's an issue for your case, and we need to review your when did you enter, how did you enter, what happened at the border, a FOIA with CBP would be extremely helpful. Or even the State Department, if we are trying to get notes or any information from what happened when you were requesting a visa, because remember the US embassies and consulates are brought under the State Department umbrella, that we can definitely file a FOIA for the State Department. EOIR and DOJ, Department of Justice, that deals with all of the cases in immigration court. And ICE is if you've ever had any interaction with the police unit of immigration, they're the ones who actually do the deportations and the check-ins. Then we can request a copy from ICE. So each agency is different. Each agency has their own regulations. Each agency has their own way of requesting a file. But bottom line, requesting a copy of someone's full file with a FOIA helps us because we can see that we can verify what was said, what was done, what was checked off, what evidence was submitted to make sure that when we apply for whatever we're going to be doing for you to hopefully get you that green card, to hopefully get you to become a US citizen, that we're prepared, that we don't have any surprises.
Okay. So let's talk about how we can assist people who are dealing with their own immigration issues right now.
Sure. Well, firstly, the first thing to keep in mind is, this isn't a one size fits all kind of thing. Every case is different. I hear often, well, my neighbor's cousin said that my case is exactly the same, and therefore I should be fine. That's not how it works. Every case is different. Which is why it's really important to review the immigration documents, because even though they entered the same way, doesn't mean that they have the same codes on their file, doesn't mean that legally they're under the same category. Okay. You definitely want to file as that's why you want to save all of the documentation that you have. You also want to understand that some immigration cases take time. So this is a side note, but the cases that we're filing right now are being processed a lot faster than cases that were filed before. You know, I have cases that I filed 2 years ago that are still pending, but I have cases, so the fastest case that we've had approved was about a month or 2 ago, and it was a green card case that was approved in 3 weeks. That's unheard of. But the cases being filed right now that are that are full and complete, we're seeing are going a lot faster. Immigration laws are evolving, the policies are changing, and you wanna make sure that you have someone that is able to review your case professionally to make sure that you're protected and you're good to go.
Okay. And I think I'm going to say the last one. It's very important that you have a professional review the steps you wish to take. I can't tell you enough from my experience, um, taking your calls, answering your emails, how many people have botched their immigration cases because they went to somebody who maybe understands how to fill out a form, but doesn't really go beyond that. We encourage you to reach out to immigration attorneys, not just people who can prepare the forms for you, because they can give you a better perspective and outlook as to how your situation needs to be handled as opposed to a generic solution for everyone. Um, why hire an attorney? Again, attorney, I'm going to take the mic on this one. I think for you guys, it's very important to have security in what your process means for the future, right? And part of that security is not having guarantees that something is going to turn out 100%, but it is having the guarantees that somebody's going to process your case in such a way that they set you up for success and they give you a realistic outlook on what your case needs as opposed to what they think or what you think you need to do. Anything you want to add to that, attorney?
Um, no, that's definitely very true. I am seeing some questions in the chat. I saw one in Spanish. I'm trying to
We
translate.
definitely need to get to those. I think a lot of these questions are surrounding the topic of time of processing times, specifically for parole cases. What do you
Correct.
have to tell us about that, attorney?
Um, okay, is there anything on the next slide that we need to share? Okay, great.
There we go.
So I'm seeing some questions about the humanitarian parole program, also known as the Biden program. Um, and there's a lot of frustration when it comes to the timing. When it comes to the Biden program, as you guys know, half of the program now is a lottery. And unfortunately, from my perspective, I don't believe that USCIS was prepared with the number of applications that they were going to receive, especially from Haiti. So a lot of people have been waiting a very long time. Um, the people that we filed for, we've done a lot of follow-ups for them, and we've tried to get different people involved. Unfortunately, there's no way to expedite the case. There's no way to give a clear answer. It's just it. I don't believe the program was executed the way that it should have been, right? Because there's so many inquiries. Um, so for now, we just have to be patient and keep following up and seeing if there's anything missing. I am seeing people, filing twice, but again, you cannot have the same person file for you twice. You need to have a second person file for you. So just keep that in mind. It's a problem on the USCIS side when it comes to that. When it comes to timing, so I saw a question about I believe it was like a 539 or 589, one of the forms,
Yeah, I believe a waiver.
a waiver that's been pending for quite some time, right? So
Correct.
there are certain cases where USCIS is delayed on. And like I said, there's also a timing issue because cases that were filed at the beginning of the Biden administration are taking longer to be approved than cases that are being filed now. This is something that we've spoken about prior, like before. It's the Biden administration has done a lot to try to expedite cases, but the cases that were already in the pipeline before they started making these changes, they're probably not done reviewing them yet. That's what it seems like. So, for example, we have a lot of our green card cases. It's very rare that we go in person for an appointment for a green card case. That's because the Biden administration made the decision to approve green cards without an in-person appointment if they see and believe that the application should be approved. That was not happening at the beginning of their administration. That was definitely not happening under the Trump administration, right? So there are a lot of changes happening, but if your case was filed before that, maybe you weren't part of the wave, so immigration is still waiting to get on that. There's also different kinds of cases that there's a huge backlog on generally. For example, VAWA cases are taking more than 2 years now. For you guys who don't know, VAWA is for victims of domestic violence that are applying for green cards because they were victims of the relationship. Those have a very big backlog. Um, Employment authorization cards. Oh my goodness. So employment authorization card based off of parole was being processed very quickly. However, if you came in on CBP1, sometimes it took a little longer. Or if you were doing it through TPS, sometimes it took a little longer. There's a handful of cases, for example, with TPS, where they filed and the application's been pending for over a year, and they've already announced a new TPS and their application is still pending, so they're just going to be rolled over into the new program because there's a huge backlog of cases. I hope that with this new TPS program that just started, there's over 309,000 people who qualify under the new TPS for Haiti. What is that going to cause as a backlog? So immigration is already delayed on some cases, and we have a huge number of people who qualify. So hopefully they'll be able to process them quickly, but again, we just have to wait and see. So I hope that was a little bit helpful. I know that it's still frustrating, right? We want our cases to be processed. We want them to be processed quickly and effectively. But it's just, a lot going on in the background with USCIS. And also they hire people, they hire officers to work for them remotely sometimes that are not really immigration officers. There's a lot of new immigration officers. The last time I went to USCIS at a local office, I had the local officer complaining that some of the new officers that were working remotely were making the wrong decision on cases, causing more issues.
Delays.
So unfortunately, yeah. Yeah.
All right, attorney, this was really insightful. Thank you so much for spending time with us this evening. To everyone in the audience, we're so happy to be able to assist you with your matters. Please feel free to contact us. Our information is right on the screen in front of you. So in terms of one more question, can the beneficiaries call and send emails or only the sponsors? So something that you do need to consider is that when you reach out to us, we need to make sure that everyone is on the same page. So if you are the beneficiary, you need to make sure that you, along with your sponsor, are the ones reaching out to us together. Why? Because we want to avoid any conflict between everyone involved. And we do think that if everyone is on the same page, it's much easier to gather all the information that we need in order to better help you. So yes, we do request that you reach out to us with your petitioner if you are the beneficiary, or if you are the petitioner, you have the option also of coming to our consultation time with your beneficiary. We want everyone to be on the same page always. Now,
Let
as
me
I
just
was
say
saying,
one more point.
yes,
So when it comes to immigration cases, unfortunately, for these cases, there's usually multiple people. It's very rare you only have one. So as an attorney and as a law firm, we have to be very mindful of that because we have to treat both parties as equal clients, and both parties need to have access to the information. And that's something that you're made aware of when you initially contact us, right? And it's definitely something that I go into when we take on a case because let's say um going into the file, the beneficiary and the petitioner are on the same page, that's when we have to address it and then we have to get off because we do have to respect both parties. But can the beneficiary contact us? Of course, yes. Can they set up the call? Of course, yes. But at the end of the day, the petitioner is going to have to be involved. The petitioner is going to have to know what's going on. And if you don't want us to let them know, then what's going to happen is we will guide you. But later on, we're not going to be able to speak to the petitioner at all. So just be mindful of that.
Thank you so much for clarifying that, attorney. So, yes, we have people in our team who can handle your situation in Haitian Creole, French, English, Spanish. We figure it out. So definitely don't hesitate to reach out if you feel like this conference was in English. Don't let that stop you. We have people who speak English, French, Haitian Creole, and Spanish. So once again, thanks to
You
everyone.
can you stop sharing the screen for 1 second?
Yes.
So moi parle créole, c'est haïtien que moi. So moi parle créole normalement, moi parle créole chaque jour avec tout client. Je parle français, je comprends le français. Alors si vous voulez parler en français avec le cabinet, on peut parler en français. And I also I understand Spanish, right? Because of the French. But our staff that it definitely is fluent in Spanish. So we've had situations where, you know, we've had all three languages happening at the same time. Just because of the nature of the potential client. So yes, you can definitely, if you guys call the office and you call and say Creole speaker, please, you will definitely be able to speak to someone in Creole. Or if you say, Español, por favor, you will for sure get someone who speaks Spanish, or French.
On the line for you. That's it. Thank you so much once again. Thank you so much for the kudos, Michelle. So we're happy to have everyone here. We hope to see you for our next webinar. Don't forget to email us or to send us your suggestions for our next topics.
Awesome. Bye, guys. Enjoy the rest of your evening. Thank you for stopping by.
Thank you, everyone. Bye-bye.